Hi, it's Mike DelSignore, Massachusetts OUI lawyer. In today's video, I want to talk about what happens if you're arrested for OUI and your case is going to be heard in the Newton District Court. The Newton District Court is a court that hears cases, state police, Newton police. Your first court date will be your arraignment. You'll enter not guilty plea, get a further date to appear, what they call pretrial. Now, at the pretrial hearing, we're supposed to get all the information from the district attorney. Often that can take one or sometimes two pre-trials. It really depends. State police, they now have body camera, so it takes some time to get the body camera to lawyers in the case. Now, according to the state police, the body camera is available right away, but the district attorneys, they have difficulty uploading it. So that's evidence we generally need to evaluate the case. The report, usually I'll have a good idea of what I think about the case from the report, but often the video can sway a case one way or the other. Certainly with a case with a breath test, if there's a video, it could help me on motions to exclude the breathalyzer. But generally, I have a pretty good idea of where I think this case will go from the report, which you'll get after arraignment. After the arraignment, then once we get all the evidence, we'll decide whether we want to resolve the case or set it down for trial. In some cases, there might be a step in between, meaning there could be a legal issue. Maybe I think the stop was bad or they shouldn't have stopped you. Then we could put it on for what's called a motion to suppress, challenging the legal basis of the stop. If that's successful, the whole case is thrown out. So two options in an OUI. Let's say it's a first offense. If you take a plea, it'd be a continuance without a finding, get a 45-day license loss, have to do a 40-hour, 14-week alcohol education program. That's the standard recommendation. That's going to be the recommendation in almost all cases. After trial, you're usually going to get that same recommendation, except it would be a guilty instead of a continuance without a finding. So it's generally not really a big downside to fighting a first offense OUI. But generally, you're not going to be too much worse off. But that's the plea. If you refused a breath test, possibly you can get back on the road with a hardship license. If it's not an extreme case, in other words, there was no accident, nothing egregious about the case, then the registry would likely grant you a hardship, assuming you get a letter from work and had a Massachusetts license. If you failed the breathalyzer, you can get your full license back after 30 days, but there is a backlog with the RMV, so request that hearing to reinstate prior to your 30 days expiring so you can get your license back on day 31 or day 32. If you wait day 31 to day 30, you're not going to get it back for another 3 weeks. So make sure you're aware of the delay in getting a hearing. You need an actual hearing to get your license back. A lot of people think after the 30 days it automatically comes back to them in the mail. That's not the case. Nothing happens automatically with the registry. You always have to go to the registry, request a hearing, which is over the phone now, and pay money. And it's $500 to reinstate after a breathalyzer failure or suspension. So once I get the report, I'll evaluate the case, determine whether I think you should take the case to trial. Now, in OUI case, it's a very subjective case. So it's really the only criminal offense where the evidence against you is, well, we think you did something wrong. We don't know, but that's our opinion. So it's a unique crime. It's not like a murder case or domestic where you say, okay, there's the victim. Something happened to them. We think you did it. This is a case where we're saying it's our opinion you shouldn't have been driving. So it's, what do they base this opinion on? The field sobriety test, one leg stand, 9-step walk and turn. Well, a lot of people can't do those tests if they don't have any alcohol at all. So there's a lot of ways to challenge those tests in court, including sometimes somebody will have a medical issue that'll explain problems with balance. Sometimes you'll be nervous. A lot of times you do well in the test and they don't really give you credit for it. There's a lot of little things they're looking for. They're going to say you fail if you do only a couple things wrong, ignoring all the things you did right. So for example, on the 9-step walk and turn, somebody who walks out 9 steps back 9 turns could fail the test by starting too soon and stepping off line once, because they only need 2 clues to fail the test. So what they say is failure, what I would deem as failure, and what a jury to judge are completely different. And I think a jury to judge is more likely to go along with our more practical version that if you substantially complied, didn't stumble, stagger, you didn't show signs of impairment. So if you got an OUI case in Newton District Court, feel free to call me. My name is Mike DelSignore. My passion is helping people charged with OUI offenses Call, text anytime, 781-686-5924. Let me help you get your life back together after an OUI arrest.